Good afternoon, it's Metha speaking. Can I please confirm if councillors are online?
Rupert Reed, yes, I'm online. Thank you.
Thank you.
Edward Knight's online.
Okay, thank you. We'll start in a few minutes. Thank you.
Good morning, everyone.
Good morning, my lord.
I'm using the telephone conference means of communication. I'm having great difficulty. Skype doesn't like me at all, but never mind. That's how we proceeded yesterday, and it all went perfectly well. So we're all present and correct. Is that right?
My lord, I believe so. Both myself and Mr. Knight are online.
You're on. Thank you very much. Let's see if Metha there. Metha?
Yes, Sir Richard, I'm here.
Good. I don't think it's necessary, is it, to have the protocol?
It should be fine.
Or is it?
No, it's not necessary today.
Yes. Right. Well, Mr. Knight, please proceed.
My lord, just before Mr. Knight does, I wonder if I could correct something I said yesterday.
Yes, of course.
I took your lordship, or I referred your lordship briefly to two DIFC decisions on the withdrawal of an admission. Overnight, as intimated, we have filed the various authorities that we think are relevant on that issue. They should appear in section 7 of the authorities bundle as updated. I don't know if your lordship has seen that.
Yes, I think that. Yes, I've been notified of that.
I'm grateful. At the very end of that clip, if you like, is a section from the DIFC Courts Practice recently published, which provides a summary, essentially, of certain DIFC authorities. I don't know if your lordship can go to the that authority.
Well, you carry on while I make my way there.
I referred specifically, and I think your lordship had in mind two cases. Firstly, the IGPL decision of the 19th November 2015, and I also referred to your lordship to a decision, again, of the DFC Court of Appeal in Dayar Development, PJSC and Tallinn, Dayar and Tallinn. The correction I would wish to make is that those cases are specifically concerned with applications on appeal to withdraw a concession that was made below. And so they're an entirely different circumstance. What your lordship therefore has at the front end of the clip, if you like, are the two English authorities that are directly on point, and which I did refer your lordship to yesterday. The first of those is Berg and Blackburn Rovers, and there are three cases, three paragraphs. I'll just give those to your lordship, those paragraphs for reference. Paragraphs 29 to 31. And then there is the ADVA Optical and Rotronic case, 2018 Again, only three paragraphs, paragraphs 16 to 18 on those, setting out the principles specifically relating in a court of first instance to withdrawal of a concession, as I say, essentially based on prospects and overriding objective.
Yeah.
My Lord, I should add that we further added a section 8 to the authorities bundle, which is essentially a section from Palmer, which deals with the point your Lordship raised on pre-incorporation contracts, and sets out the common law position, which is that if a pre-incorporation contract is purported to be made by a company which doesn't exist, the contract is a nullity, and neither the company when formed nor the promoters whose signature is added can normally sue or be sued on the contract. So we would say that the common law position prior to the 1985 Companies Act, and specifically section 36C of that act, provided in the circumstance your Lord sketched, i.e. where goods have been delivered by a company which is then expecting payment, the very anomalous injustice which your Lordship suggested may occur as a matter of UAE law would occur in English law, or English common law, in the circumstances of a pre-incorporation contract. So in other words, yes, the third party may have the advantage of not being required to pay its debt under the contract found to be invalid. And one can speculate as to if that decision as to invalidity was not made by way of declaration, whether other third parties dealing with the company would have the benefit of the invalidity. And my submission would be that if there hadn't been a declaration, if they were unaware of the judgment, then they would not have the benefit, as debtors of the company, of that invalidity. So again, the second wrinkle in terms of potential injustice would exist equally as a matter of English common law in seeking to vindicate the English public policy of requiring promoters of companies to get on and incorporate companies if they wish to take advantage of separate legal personality. And your Lordship has the newborn and sensitive case, which is relied on by Palmer.
That's an old chestnut, isn't it?
It's an old chestnut, my Lord, as your Lordship indicated.
Yeah.
And I apologise for interrupting, but I just wanted to make those few points.
Thank you very much. It's all been loaded onto the e-bundle. I have it all in front of me. But thank you very much. Yes, Mr. Knight.
My Lord, as to the authorities on the English position on companies and contracts and invalidity, I'll have to address that in writing afterwards. I received them 10 minutes ago. But I do want to address the admissions points first. It won't take long, but my learned friend went through it in some detail yesterday, and now we have a number of authorities. As my learned friend says, as he also being the editor of the learned work, the DIFC Courts Practice, he points out on page 1017 that there is no direct relevance of these applications for permission to withdraw concessions to the withdrawal of admissions within Part 15. However, I think there are principles that one can take from them. They're not entirely separate, and that is no doubt why my learned friend has included a discussion of IGPL at two instances under this head. The main difference, of course, or a very large difference, is that the withdrawal of a concession doesn't fall within Part 15, and therefore the criteria to which the court has regard in 15.53 don't apply. And of course, the court must give those the proper consideration when considering withdrawals of admissions. I should say that in neither IGPL nor in Mr. Justice Mann's case, the BT Pension Trustees case on which Chief Justice Wang essentially relied, was there any mention of the DIFC Rule 15 or the English Rule 14 in Mr. Justice Mann's case. But we do accept that there are similar principles that can be gained from what is said in IGPL. And if one goes to the IGPL case, which my Lord is page 957 of this section 7 of the authorities bundle.
Yes, I'm there.
And if we then go to page 966.
Oh, I'm sorry. There are two, aren't there, in the list? There are two.
There are now two. This is the one in section 7.
Oh, okay. Yes, in section 7. Yes.
And
yes,
it's
thank you.
Paragraph 51 at page 966.
Paragraph 51. This takes a little time to load up, but we're getting there. Yes, I'm there.
Great. These are the criteria that are really just come straight from the BT pension scheme case, but have been adopted by Chief Justice Wang. And if we go through them in turn, as my learned friend did yesterday, you can see just from Roman 1 that the resiling party has the burden of establishing that the previously foregone point should be raised, which again makes clear on whom the burden will lie in this sort of application. It will be harder to raise a point which has been expressly conceded. Well, yes, that is dealing with concessions. We, of course, are dealing with a written admission. It is an express admission, as we discussed yesterday. And at 3, we can see if taking the point would cause prejudice to the other party. This is where it slightly differs, in the sense that it might have been deprived of the opportunity of dealing with the case differently in the court below. Then it's unlikely that resiling will be allowed. The greater the risk, the less likely it is that it will be allowed. Now, in my submission, one could take the principle that one should look at prejudice, and you merely adapt, because prejudice is a criteria under Part 15. You merely adjust to the sorts of prejudice that one will suffer in the case of withdrawal of admissions, which we discussed yesterday. He then goes on to say there's a low threshold of the risk for these purposes. So not a great deal of prejudice has to be shown. And the burden of establishing no risk is on the party who wishes to withdraw the concession. And the other party should have the benefit of any doubt. And we say that those are similar principles that should apply to the prejudice element of the argument under Part 15. There is a very high burden on OIC in order to withdraw their concession. It is not lightly done where they have expressly admitted the case to the contrary, and they have to show very, very little prejudice or no risk of prejudice according to these criteria. That said, the actual criteria, or not in the DIFC court, but the English authorities on the criteria under CPR 14, which are reflected essentially in Rules of Dubai Court 15. They're set out, if one goes to Henning-Berg, which is the first tab of section 7, my lord.
Yes.
Starting at,
yes, I'm there.
I'd go to page 938, which is 937, 938,
Yes.
where the principles are discussed. And essentially halfway down page 938, one sees
Yes.
what has generally been accepted throughout the authorities as the proper test with respect to admissions. And the first is very important, though at first blush, it might be said that it slightly, not so much as elides, but underplays the express provisions of criteria A, which is the grounds, which is the absence of new evidence in the light of which the admissions have been made. But in my submission, really, the reasons and justification for the application at Roman 1 which must be made in good faith, incorporate consideration of the evidence that may since have come to light. But I want to emphasize that Roman 1, the reasons and justification for the application, which must be made in good faith. Because, of course, in this case, we have no reasons given for the failure to plead the nullity defense from the start. We have no justification for it whatsoever. All we have is Mr. Kishor's evidence that it was contemplated at the time, but deliberately not done. And that must have been with legal advice. But there is nothing to infer that can lead the court to infer that this has been done in good faith. And I emphasize in this respect that the evidence for the nullity point, the entire basis of the nullity defense, is a statement in the preamble to the agreement that the OIC parties, particularly that Synergize was a party to, and that OIC approved. All the information on which they rely was on the face of the agreement that they signed at the time. It was the express basis of the agreement that were to be performed. It wasn't hidden from them. They didn't subsequently find out. It was the basis on which they contracted, and it was expressly acknowledged in forming the contract, and that is what is now being used to resile from the contract, whereas at first they admitted that the company was valid.
Could I just make this point to you? In some of the resiling cases, all that is happening, I say all that is happening advisedly, is that an admission is being withdrawn. In the case currently before the court, there is a resiling from an admission, but then a related amendment filling the vacuum. And so one has to have in mind the two elements. First, that there is an admission that is being departed from, but in addition, that a new pleaded case is being introduced at one and the same time. And so we may have two streams of principles, which to some extent run in separate channels, but also, it seems to me, converge somewhat, and you have a sort of mixed stream of consideration.
My Lord, I entirely agree. I think they do merge, and one has to look at, they're both in all the circumstances. There is different emphasis on each part. But I think it's clear when one looks at the Adver case, Adver Optical, which is the next case on this list that we don't necessarily need to look at because it doesn't really say any more. But certainly in that case, the judge was referred to all the cases on amendment at the same time.
Yeah.
They are all relevant. It is obviously just more important where there has already been an admission to the contrary, that one has a good reason for the change and for resiling from the original position. And obviously, the evidence previously having been available is an extremely important part of that. My Lord, just to go on from the other, to look at the other criteria, again, we then come back to the balance of prejudice to the parties. That obviously is a matter we discussed yesterday, and as I say, one could look towards the IGPL stroke Briti pension trustees cases for guidance on that. Whether any party has been the author of any prejudice they may suffer, well, of course, OIC has been entirely the author of any prejudice that it may suffer. It has known about its case all along and has failed to bring it before. The prospect of success we dealt with yesterday, and the public interest in avoiding, where possible, satellite litigation, disproportionate use of court resources. So there, my lord, you have your point about everything else, and the impact, of course, of strategic manoeuvring, of which you as part of the JJC have already complained. And then finally, the proximity of the application to a final hearing, and we discussed that again yesterday. The only other point to make is the paragraph that follows, or the remainder of that paragraph, talks about the overriding objective. And as we said yesterday, notwithstanding Denton, it is certainly true that courts, and in my submission, the DIFC in addition, take a more stringent view of complying with rules than they previously did, notwithstanding there being some rowing back. My lord, Adver Optical start at page 948 of the same bundle, essentially, as I say, refers to the same formulation and goes on to the authorities on amendment generally. That's all I intend. That's all I intend to say about that. They are, I think we can say, takes matters no further forward at all. And with that, my lord, I then turn back to GlobeMed's application to strike out.
Yeah.
My lord, just while you're looking at 948, 949, could I just draw your lordship's specific attention to paragraph 18, which makes good the point
Would
that
you
your
just
lordship...
wait a minute. I just want to get it on my screen. Forgive me for a moment. It's page 948. I'm just getting it.
And my learned friend was taking you to the principles.
Yes,
those principles, which are specifically the principles apply when an admission is being withdrawn before the same court. And your lordship has my point about IGPL being on appeal, a withdrawal of an admission made below particular issues.
You've made that.
I've made that point. But so here we have the Court of Appeal principles specific to our situation from the Sowerby and Charlton decision. But I would just, going over page to page 949, draw your lordship's attention to paragraph, well, first of all, 17, which identifies a particular passage from the deputy judge in Berg and Blackburn Rovers, where he emphasises, as your lordship will see, in my judgment, the correct way of approaching an application of this sort is to start by asking whether the defendant has demonstrated that if permitted to withdraw its admission, it would have a realistically arguable defence. And that, as your lordship will recognise, is essentially the test applying on amendment, and that is essentially the basis for the argument of an overlap. And one sees that at paragraph 18, the following paragraph. The approach taken by His Honour Judge Pelling in the Berg case is consistent with the need to look at whether there's a reasonable prospect of success in the context of an application to amend a pleading. It's been submitted to me, and I accept that there's a considerable overlap between these two jurisdictions of amendment and withdrawal of admissions. So essentially, in a very broad sense, it's a very similar test, as we say, in terms of looking firstly at prospects and then at overriding objective.
Yes, thank you. Yes,
Sorry,
Mr. Knight.
I'm obliged, my lord. The GlobeMed strikeout.
Yes.
My lord, as I said yesterday, this in particular shouldn't take terribly long. It's a simple point, but we don't say it's any less effective for that. If I could take you to the pleading of the new claim, which appears at page 112, I think behind section 2 or tab 2 of the main bundle.
Pleadings. Well, wait a moment. Let me just see.
It's the pleading of the new claim, the 2020 claim.
It's the new claim, isn't it? Yes.
The 30th of January 2020, and it should start at page 109.
Is it? Oh, yes. It's CFI 011-2020.
Yes.
Is that right?
Yes.
Yeah.
So it starts at page 109.
Yes, I'm there. Thank you.
And then goes through the parties with the intended transaction,
Yeah.
which your lordship understands well, then paragraph 15 at the bottom of page 111, the relevant clause 3 of the MOU, which provides for the acquisition of 51% of shares in GMGHS, is set out. And then at 17, we have the breach that is alleged. Now, as I've made clear in my skeleton, and has been dealt with in part yesterday, this is really Synergize's claim against GlobeMed and Karma. Now, I won't deal with Karma for the moment, but this is not OIC's claim, and it is not a claim against GMGHS for anything other than this right to a set-off. There is no cause of action against GMGHS, and there are no damages claimed by GMGHS. OIC has no cause of action, and OIC does not claim any damages. Now, the MOU and the TPA are clearly part of an overall transaction, but they are distinct contracts with different parties to each of them. And we looked yesterday at the provisions for when the MOU came into effect, which is at page 65 of this same bundle.
Yes, just remind me of, I mean, we looked at it yesterday, but just remind me what it says.
MOU shall enter into effect as at the date of its signature by the parties, period of 2 years. Now, there is no doubt that this agreement became immediately effective. And it is far from clear, because in the original claim, the main defence is that the TPA had never commenced.
Yeah.
Even though it had been executed, it had never commenced. But that can't be said of the MOU. The MOU has been executed. It has no date it should commence other than it enters into effect on the date of its signature. There cannot have been the ability of Synergize to get out of this contract, other than by agreement, save by repudiation. It did start. So when Mr. Schoffel emails 21st of May, it can only be repudiating that contract. That, my lord, appears at page 72, that email. I know, my lord, you've seen it before.
Yeah.
It is very clear it is cancelling the joint venture, which is the MOU, as well as TPA service agreement. Now, what essentially is being said in the email is we will not buy the shares in GMGHS. We do not want them. We will not pay for them. Now, the relative or absolute values of either side's consideration are irrelevant. It may be that the only consideration is $1. It may be that the value of the shares is expected to be more in due course. But that is the consideration. It is good consideration, and it has to be paid. We'll note that in the pleading, no credit is given for that dollar. Now, notwithstanding, or in circumstances where Synergize have said, we will not proceed with this contract, we do not want the shares, and we will not pay for them. They now say, but we can sue you for breach in your failure to transfer the shares to us. They're suing for damages for breach of the failure to deliver which they refused to take and said they did not want and would not pay for. It's not hard to see in our submission that there are obvious problems with that, essentially relying on their own breach to sue, to actively sue, not defence, but to actively sue the other party for damages.
Forgive me, sorry to interrupt. If a party repudiates and the other side refuses to accept the repudiation, the repudiating party, it is open to the repudiating party to repent.
Yes.
And to re-establish, if you like, the contract. The
yes.
Contract's been kept alive.
Yes.
And if that is the case, on the facts of this case, there would be a tendering of the $1.
Yes.
And there should be the necessary instruments of transfer and so on to have the shares paid over.
Yes.
Now,
but there was no tender.
There's no there's no tender. There's no claim for specific performance.
No.
There's no claim that this obligation must be performed.
No, there's been no request for performance. Any manner.
Is a claim only for damages. Now, just while the thoughts in my mind, just bear with me. So far as damages are concerned, in this sort of case, it's a counterfactual inquiry. And so it may be that the calculation of damages, I'm not sure, I haven't thought this through, but it may be that the calculation of damages will be on the assumption that both sides of the agreement have been performed. In which case, that is an assumption that includes the transfer of the shares for a consideration of $1 million.
$1.
So, for instance, in the main claim, sorry, for $1, do forgive me. In the main claim on the TPA, it's an expectancy loss that's being sought.
Yes.
Parties are to be put in the position as if there had been performance, which would include the transfer of the shares.
Well, except that it's not the difficulty is that it's GMGHS's claim.
Yes, I understand.
Not GlobeMed's claim. So GMGHS will make all the money.
Yes, it's GMGHS's claim. No, I understand that.
I'm sure.
I understand that. Well, these are untidy thoughts, but just coming back to this new claim, there's a claim for breach, which has not been preceded by a tendering of the money and a declaration of readiness to receive the instruments of transfer and so on.
Yes. Yes.
And you say, well, there can't be a claim unless the clock's been put completely back. The repudiation is withdrawn in its entirety, and there's a tendering, and in which case the whole of the composite transaction is back on foot.
Well, we say this part.
Yes.
Well, we say that the MOU is back on foot, and yes, it's our case that there was no repudiation of either contract, no effective repudiation, because they're both open.
Yes, that's right.
However, the difficulty that Synergise now faces is that the MOU was only effective for 2 years, and it was obliged to do everything within 6 months. So it lost its ability
Yes.
to fulfill the contract after 6 months,
Yes.
we say, or at the worst 2 years. Now,
Yeah.
I describe that as through obduracy or self-belief, or a better word is probably hubris. But it has entirely been the author of its own misfortune. It had no possible reason, no possible method short of repudiation to terminate the MOU. It can't be said it didn't commence. It's absolutely clear on its face that it did commence.
Yeah.
And they could have put it into effect at any time, but they did not, or they could have got what they were to which they were entitled. Now there are other provisions to which my learned friend took your lordship yesterday, as to what happens if the TPA ceases, but that doesn't stop the initial rights from being effective, and that is what they should have done. And it really just shows that both agreements were effective. It is an argument essentially against the primary defence of my learned friend of OIC.
And this new claim is brought outside either the 6 months or the 2-year period, whichever may be the governing period, that determines the term of the agreement.
Yes, far outside.
Far out. Yeah.
Even the 2 years would have finished on the 13th of January 2017.
Yeah.
So this is 3 years left time for that.
Yeah.
Now, my lord, we've gone through what might be said to be the bleeding obvious, and unsurprisingly, the UAE Civil Code takes account of exactly this sort of thing happening. In Articles 247 and 556. My lord, I've set them out at paragraph 74 of my skeleton argument.
Yes, I'll just turn that up.
It is fair to say that I took these from a different translation to the one which has eventually appeared in the bundle.
Yes.
But I don't think there is any material difference in the various translations.
Yes.
Article 247, in contracts binding upon both parties, if the mutual obligations are due for performance, each of the parties may refuse to perform his obligation if the other contracting party does not perform that which he is obliged to do.
Yes.
So there we have. How can we possibly, if Synergise is refusing to continue with this contract, how can we possibly be expected to perform our part and end up having to sue them back? And then Article 556, the purchaser must pay the price when the contract is initially made and before the delivery of the property and before a claim is made for it, unless a contrary agreement has been made. Well, there isn't any relevant contrary agreement. The parties were given 6 months in order to do everything, but there is no contrary agreement that the price should be paid after transfer, and certainly not certainly no alteration to the principle that it must be paid before a claim is made for it or before delivery. And we say together that those just reflect the obvious, simple law that you cannot rely on your own default and sue for the other party's breach when you have refused to perform a contract.
Yeah.
And that is the short point, which on which we rely to strike the claim out.
Yes.
If I can just deal very briefly with karma.
Yes.
It's quite clear the same does apply. Now, we rely on that not in relation to this application, and there is no implication or no inference should be drawn that either I nor my instructing solicitors are, could, or should be acting on behalf of karma. When it is served, it can make its own application in due course. But in my submission on behalf of GlobeMed, when we come to the management application, it is relevant that the claim will be likely struck out as against karma in any event. While I'm on the subject of karma, my learned friend has said in his skeleton argument that karma is insisting on formal service of the new claim. And that's at paragraph 7 of his skeleton argument. He referred yesterday to having written to Clyde & Co., who instruct me and are instructed in turn by GlobeMed and GMGHS. They wrote to Clyde, who replied that they were not instructed by karma. We haven't seen anything to suggest that OIC or Synergize have written to karma itself to see whether it will accept service in any other manner. So to say that karma is insisting on formal service, we have seen nothing that makes that good. It appears that service is being undertaken in no other attempt to contact karma at all. My Lord, that's all I want to say on karma, and I think that deals with the GlobeMed strikeout application. My Lord, I don't know whether you would like my learned friend to respond on that application, or I should go straight on to the GMGHS strikeout.
No, I'd like to go straight on. And
I'm grateful.
I'll hear Mr. Reed on both applications.
I'm grateful. My Lord, as we've seen, it's common ground that there is no cause of action between OIC and GMGHS.
Yeah.
If there was, be a counterclaim in the main proceedings.
Yeah.
If I could go back to the new claim, just to look at the set-off point quickly.
Yes.
When my screen has stopped dancing about. It's page 13 of the main bundle.
113 or 13?
13.
Is this the?
Section 2, I think it is.
Well, I've got a heading pleadings.
It's pleadings in the new claim again, the 2020 claim.
Yeah. Okay. Well, that begins at page 109.
Yes, and the set-off is pleaded at 113.
At 113. Fine. Okay.
13.
Yeah. Yes, I'm there.
I'm grateful, my lord. My lord, I suspect I don't need to labour this point with you. But as I've repeatedly said, there is no direct claim. What is said is that OIC is entitled to set off Synergize's entitlement to damages, and against any sum OIC may be ordered to pay GMGHS.
Yes.
Is on some manifest unjustness and close connection because of the relevant shareholders. Now, I want to make this very clear. This is essentially OIC claiming that it should be entitled to set off the debt of a third party to a fourth party against its own debt.
Yes.
This isn't just a case of setting off a third party's debt to the person who owes you money, or managing to use their debt in some way, not capable of being remedied by assignment.
Yes.
This is completely unrelated. This is Mr. Reed owing me money and me claiming that I can get Mr. Killen's debt to you.
Yes.
Now, the issue's been dealt with at some length by Mr. Mutaseb in his evidence, and I've made comments on that yesterday. He has indicated that not only do they rely on the judicial set-off under UAE law, but also a procedural equitable set-off under IFC procedure. That appears to have been abandoned by my learned friend. It doesn't appear in his skeleton argument, and I would say in any event is doomed to fail for the reasons I've set out in my skeleton, that the concept in English law, or in the common law world, even if we're dealing with an equitable set-off in the common law, they must be mutual obligations. They only arise out of claims and counterclaims, and they have to be owed between the parties themselves. There is no concept over hundreds of years, there has not been a single instance of somebody being able to set off a debt owed to somebody else by somebody else. The authorities are clear on that, and I've put them in my skeleton. So what we come to is the UAE.
Just to interrupt you. The sort of situation which the court's now presented with in common law jurisdictions is dealt with by the execution process, where there's a range of possibilities where you seek to attach a debt owed to somebody else, or there are possibilities of injunctive relief, such as freezing orders and so on. There's nothing in the common law, I think this is common ground, that recognises the sort of set-off that's been pleaded here. This is a set-off which is peculiar. If it is a good set-off, it's a set-off that is peculiar to the UAE and possibly other jurisdictions that adopt the notion of judicial set-off with possibly some variations.
That's what we say. I would say you can plead. You can obviously plead in English law. You can plead a set-off as a defence prior to the execution. That's perfectly normal. But as regards third parties, yes, there are third-party debt orders. But of course, even that is a debt to the person that's actually involved. It's not this strange third, fourth-party debt. So there is no concept of it.
No. Yes, go on.
So then we come to judicial set-off. It appears to be common ground also that no other set-off is available, even under UAE law. The voluntary set-off has not been agreed to, and the mandatory set-off is not available. It is only said that judicial set-off is available.
Yeah.
Now, perhaps the fundamental flaw in both Mr. Mutaseb's reasoning and my learned friends is their studious avoidance of Article 368 of the Civil Code, because that is the one which sets up set-off as a concept. My lord, it is dealt with at some length in a case which, yet again, you were part of the tribunal. in the other IGPL
Yes.
case,
Yes.
which is at page 159 of the DIFC authorities.
Yes. Yes. I'm going to it now. Yes, I'm there.
So bear with me, I'm just getting my correct page references. It starts page 159, and then at page 165, so that we've got it in one place. Paragraph 23
Yes.
are the relevant provisions of the UAE Civil Code.
Yes.
And if you look down to the bottom of the page, Article 368, a set-off is the satisfaction of an obligation owed to the obligee by an obligation owed by him to the obligee.
Yes.
So there are only two people involved in this.
Yes.
Article 368, as we'll see, is a requirement of mutuality. And for some reason, Mr. Mutaseb and my learned friend both seek to avoid mentioning this article, which sets up set-off. It is the fundamental precondition to all set-offs. Article 369 just explains the different sorts, and then 370 to 372 explain those different sorts in more detail and when they apply.
Yes.
Now, it's worth then, obviously this is a decision of the DIFC court, and if we go further down, perhaps to paragraph 105, which appears at page 179,
Sorry, it's taking a little bit of time.
likewise, my lord. But what we get to on page 179 is substance.
Yes. Go on.
It starts at paragraph 101 at the bottom of 178, the conditions of
Yes.
judicial set-off.
Yes.
And then this follows a long review, and it gets to paragraph 105. It deals with Professor Al-Sanuri's commentary on Egyptian law,
Yes.
in which it remarks on, or includes the extract on two correspondent debts in which the defendant may not make a legal set-off, etc., etc. What this is really dealing with, and has been highlighted, is the absence of two other requirements of legal set-off, and that is the absence of dispute and the predetermination of the value. The correspondence of debts remains. So when there is any reference to not all the requirements of mandatory set-off being required, they are to those requirements, not to the correspondence of debts.
Yes.
At 110.1, and I should say there's an error in paragraph 105 of my skeleton argument where I've referred to the decision of the DIFC being at 110.1. It's actually at 113.1, as we'll come to. But 110.1, the Chief Justice refers to SCB's submissions on the requirements of legal set-off, that both debts must be reciprocal, such that both parties are simultaneously debtor and creditor of another. And I suggest that that really derives from and it is simply taking as a synonym correspondent debt for mutuality or reciprocity of debts.
Yeah.
And that,
Yeah.
lo and behold, is the decision to which the court came at paragraph 113. Nonetheless, it's clear to me that the preconditions for judicial set-off to be applied, as determined in the Dubai Court of Cassation's decision in Petition 129/2009, are likely to be correct. They are as follows. The two parties should be creditor and debtor to each other only. And there we have it. The looser connection point, to which I'll return at the end, is very much like the equitable jurisdiction in the English common law, that your debts don't have to be strictly related, which they do for a legal set-off, just in the same way. An equitable one is a looser connection, but it doesn't get rid of the point that they must be mutual. The debts may be disputed, and the debts may have non-determined value, and those are the differences to the mandatory set-off.
Yeah.
I do have to accept that at paragraph 114, that finding is rendered obiter because IGPL didn't get over the initial requirement of finding an independent claim, so the court doesn't need to consider the conditions for judicial set-off, though, as is so often the case, it has done already. But we say that the reasoning is entirely sound. There is no real prospect of a court coming to a different conclusion, particularly when one looks at the cassation judgments that we've put together. These are as many as we could find. We have been able to find nothing to the contrary. So if I could start with cassation 345 of 1993, which is at page 892. So 345 of 93, my lord, page 892 of the Dubai, of the UAE authorities.
Okay, wait a moment. UAE authorities. Yes. And 892. I've got it. Yes, I'm there.
I'm obliged. And as with so many of these, well, actually, this one is comparatively long, but the decisions are made fairly clear, and the criteria are made clear without a great deal of explanation of what was actually happening in the background. But this has to do with the set-off of a credit card debt by either the husband or the wife against a debt owed by the other.
Yeah.
To say it is somewhat beyond me as to who was actually the debtor and who owed whom what. However, at numbered paragraph 2.2 on page 892, we see the conclusion. The judicial set-off conditions include as follows. In addition to initiating a judicial set-off through an original claim or a counterclaim. So there we see you do actually have to have an original claim or counterclaim. The set-off itself is not an original claim or counterclaim. You have to have one in just the same way you have to have one for an equitable set-off, the English law set out in Hannock and Green. It is conditional that the two debts are opposite. i.e., the two parties to a set-off shall be a debtor and a creditor towards each other in the same capacity. My lord, in a nutshell, is our case. Stated boldly, it is as it is in the following case at page 896.
Yes, and that.
Cassation 28 of 20JY, number paragraph 2.1. It is established by this court that set-off regulated by articles 368, 370 and 3 civil 2 is the satisfaction of a debt owed to a creditor by a debt owed to his debtor. Set off may be mandatory or judicial, etc., etc.
Yeah.
Next, we have Cassation 306 of 2000, page 899.
Yes.
And if one goes to page 902, you'll see in the first full paragraph on the page, this challenge is refuted. Article 368 of the Civil Transactions Code, enacted under federal law, that set-off is the satisfaction of a debt to the creditor by a debt owed to him by the debtor. Article 372, etc., judicial set-off.
Yep.
Next, skipping one authority in the bundle, it's to 67 of 2004, which begins at page 912, but that's just the cover sheet. If one goes to 913,
yes,
2/3 of the way down the page, it refers to, and Articles 368 and 369 of the Civil Procedure Law stipulates that the set-off is the fulfilment of a debt payable for a debtor with a debt required by the creditor.
yes,
The next paragraph, the final sentence, under Article 372, the judicial set-off is carried out by the court by a claim or incidental request of the court, considering the action of the debt to be set off with the same conditions of the legal set-off, except that the absence of dispute and definite amount conditions where the cause of the two debts may be different. So it's the cause of the debts, not the incidence of the debts. And then finally, 209 of 2011J, which earlier in the bundle, as this was a 8. And one can see at 885, once again simply stated under number 2, set off pursuant to Articles 368 and 369 of the UAE Civil Transactions Code is the settlement of a debt due to a creditor against a debt owed by him to his debtor.
what?
My Lord, those are the authorities that we have managed to find and translate. We have not been able to find any instance in which judicial set-off has been allowed where there is not mutuality of debt. And essentially what Mr. Mutasev has done is to use the words connection and simply to ignore everything to the contrary and to say that still leaves it open to us to argue. It has already been argued in the DIFC, as we've seen in IGPL. It is regularly argued in the UAE courts, and always with the same result. It is quite clear that this is the settlement of a debt due to a creditor against a debt owed to him by his debtor. And it is only by eliding the fundamental Article 368 that Mr. Mutasev or my learned friend can get anywhere. Correspondence, in summary, is mutuality. OIC or Synergize is looking at things. OIC is looking at things the wrong way around. Correspondence does not mean that if the debts are in some loose way related, that mutuality is irrelevant. The law is, both in English law and in the UAE, is that if there is a mutual debt, whether or not they're related is irrelevant for equitable or judicial set-off. Now, something is made my learned friend about the reason why this is so unfair is because they are left suing a Lebanese company and a BVI company when it would be so much easier for them to enforce against GMGHS, which is a UAE company, and they are going to owe the money and they could simply deduct it. Well, my lord, it is not unfair to pursue their contractual debtor simply because taking the money from a third party is more convenient. GMGHS doesn't even have a debt to GlobeMed. It's a matter of dividends that it may or may not receive in due course. It may be tied up with issues of reflective, or it would be tied up with issues of reflective loss in English law. But OIC can't simply walk all over the doctrines and principles of corporate personality, privity of contract, the law of obligation, insolvency, simply for the convenience of a putative creditor. But there is absolutely no prospect of a set-off succeeding in a DIFC court or in any other. Mr. Mutazeb's evidence is conceived, and in my submission, immediate judgment can easily be entered in favour of GMGHS.
Yeah.
My lord, those are my submissions on that, unless I can assist you any further.
No, well, thank you very much, Mr. Knight. And as we have agreed, the management question we're going to park for the moment. And so I'll hear Mr. Reid in reply on both of your applications. Thank you very much.
My Lord, thank you. If I could start by looking at GMGH's application itself. Your Lordship has that in the hearing bundle at page 1668.
Yes. I'm just so sorry, Mr. Reid. Who's application? I'm just looking at the list.
Sorry, this is. I'm starting with GMGHS's application, which was the one made first in time.
Yes.
That, as I say, is paragraph page 1668 in the hearing bundle.
I'm sorry to be so.
No, don't worry, my lord. It's Harper orders.
You're working off the standard e-bundle, are you, Mr. Reid?
Well, no. What I think most of the advocates have done is download a PDF from the bundle, and that allows us to add bookmarks, which are essentially electronic tabs. So we can just we can just press a tab in the right-hand margin, and we go straight to the document.
Okay. Well, I've got a heading 3 in the hearing bundle, which is and there's a defendant's application.
So I'm 1668 should be in tab 5, the third defendant's application.
Oh, I see. Thank you. Yes. Yes. Oh no, something got completely haywire has happened. Oh God. I'm sorry. We're going to have a pause for just 2 or 3 minutes. I'm going to have to reload the e-bundle. Something seriously has gone wrong here. So just
My lord, would it be
45.
would it be worth taking it? Would it be worth taking a 10-minute break before I sort of start in
Yes,
earnest? And
yes. What a good idea, so that you're not left. Yes, that's a
then
good
I can,
idea. We'll resume. It'll be 11 minutes or so. We'll resume at 20 past the hour.
great for me.
Right. Thank you. Hello.
My lord, hello.
I'm sorry it took a little longer, but I'm now all set. And I'm looking at the application form, the application notice.
My lord, I'm grateful. This was the first application made on the 1st of March 2020.
Yes.
My learned friend will take the point that at this stage, GlobeMed itself was the BVI parent entity was still awaiting service. It was served on the 15th of March, and then on the 30th of March, GlobeMed brought its own application. But looking at this first application, what's conspicuous is there's all that the application notice does in Part A is identify that it's an application for immediate judgment or strikeout. In terms of the grounds for strikeouts, you'll see, Your Lordship will see 416(1), which is the merits test, if you like, and/or 2, abuse of process. So there's an argument on the face of the application that the synergized, the new claim, the synergized claim, is itself an abusive process. There's no explanation in Part A as to the basis of that allegation. All Part A then does in terms of the explanation is recite the tests for immediate judgment and the tests for strikeouts. The application was accompanied by a witness statement, that of Mr. Lewis, the first witness statement of Mr. Lewis, which again provided no explanation of the basis of the strikeout application. The only point of substance it made in paragraph 7 was that GMGHS was not a party to the memorandum of understanding. In simple terms, the privity point indirectly raised the set-off issue. So at this stage, no issue was being taken in respect of the synergized claim. Very indirectly, a point was being taken in respect of the set-off issue. But as your lordship suggested, at the heart of this is the merits of the synergized claim. If the GlobeMed is to be put in the position that it would have been in had the joint venture on its analysis been performed, assuming the renunciation that it alleges, then one has to take into account the issue of shares under the MOU. And to do that, one has to join both GlobeMed and Synergize. They need to be part of these proceedings in order precisely to do justice by putting GlobeMed in the position that it would have been on its case if the contract had been formed. Now, I think there were two elements to Mr. Knight's applications. Firstly, the Synergize claim itself, which is obviously brought into relief in GlobeMed's later strikeout application. And secondly, the set-off claim, which is raised specifically in GMGHS's strikeout claim. And I'll deal with them in the same order that Mr. Knight did. I do wish to, before I do that, just emphasize the test for reverse immediate judgment and indeed for strikeout. And there's been reference to the Easy Air yesterday, to the adoption by Justice Giles in Nest Investments of the Easy Air tests. So the issue of realism, not conducting a mini trial, and I should say, in addition, the issues of where issues of foreign law are involved, the court has to be very cautious in giving immediate judgment or striking out where there is a real prospect or a real argument that those issues should be determined at trial on the English approach by way of expert evidence and the cross-examination of experts. And I would draw your lordship's attention too to the remarks in Easy Air about the requirement to hesitate. The court should hesitate where there are reasonable grounds for believing that the fuller investigation of facts would affect the outcome, particularly on issues of foreign law, where one at the moment has the submissions, the evidence of Mr. Mutasser, his carefully considered views as a UAE lawyer, as against the assertions made by Mr. Knight, who's not a UAE lawyer, in his skeleton argument by reference to certain Court of Cassation decisions which, on his analysis, support the case that he's making. So we would say these are circumstances where the court should hesitate before giving immediate judgment. There's been reference to the actual life and Ernst & Young decision. I don't think we need to go back to it. For your Lordship's reference, that was the authorities bundle, tab 3, page 596 at paragraph 38. And the reference there was made to the danger of trying cases summarily where there is no cross-examination. So the court must be mindful of this sort of application as to where cross-examination may be particularly relevant in testing arguments, testing obviously issues of fact, but also testing issues of foreign law by permitting the cross-examination of the relevant expert. On the issue of mini trials, one has to ask if the application heard over a number of days is simply reducing the trial by a similar number of days, then one is doing two things. One is either effectively hearing a preliminary issue, but to hear a preliminary issue, one has to hear precisely the same evidence that one would be hearing at trial. Alternatively, if one is having a hearing measured of an immediate judgment application that is measured in days, then one is having precisely the mini trial that the authorities warn us against. In my submission, there are cases where immediate judgment and strikeout applications over a number of days are justified. But when one looks at the cases, they tend to be of situations whereby a 2-day summary judgment or strikeout application can cut weeks of trial time. And that is where these sort of applications add value. But where one is having an application on relatively scant evidence without cross-examination, there is, in my submission, real danger that the court is doing exactly what it shouldn't and is risking disposing of significant issues by way of mini trial. So looking first at the synergize claim, it should be stated from the outset that our primary case is that the JV came to an end, that the TPA is not effective. Our alternative case, if at trial we're wrong, if the TPA is effective, is that the MOU is similarly effective. It is said that we renounced the TPA. I'm not aware that renunciation was formally accepted, and indeed I recall reference in the pleadings to the fact that there was no acceptance of the alleged renunciation or repudiation. The agreements are, in our submission, very clearly related. I note the starting position of Mr. Knight in beginning his attack on the set-off claim, that the claims were completely unrelated. I note that as the target he essentially sets himself. In our submission, it's very clear from the MOU that they are entirely related, notwithstanding the subtle differences of companies, the companies that are involved. When one recalls Article 5B of the MOU, which provides that OIC remains the client of GMGHS for as long as Synergize is a shareholder of GHGS. When one bears in mind the ownership by GlobeMed of GMGS and by OIC of Synergize, the coincidence of the parties is very clear. The relationship, similarly,
Mr. Reid, so sorry. I'm so sorry to interrupt you. I just want something clarified. You're not submitting, are you, that the TPA was not renounced by your clients?
I think the Shopwell email. I think your lordship is right. I think it is a renunciation. But I don't want to be held to making a formal admission before I've. But I don't think we are.
I can understand understand that.
These sort of council's comments can be very dangerous.
And I want to put you on warning that I'm highly likely to proceed on the settled basis that there was a renunciation of both agreements, the MOU and the TPA. Now, what the significance of that is will depend on a lot of argumentation and analysis and so on. But it's a matter of construing the email, and I think it is plain on the face of the email that both components of the joint venture were being renounced. So I'm sorry, I thought I ought to give you a heads up as to that. And I'm sorry I had to interrupt the flow of your submissions. Do continue.
That's helpful, but we take the point that your lordship made to my learned friend that in terms of assessing the damages for any breach, one has to look at the counterfactual.
Yes.
And so to that extent, we say it's necessary that Synergise be made a party by the additional synergised claim, in order that otherwise one is seeking to assess that in the absence of Synergise as a party, and that's why we say the Synergise claim needs to be made and needs to be added. In terms of the, I was describing the interdependency of the two claims. We say again, it's evident when one looks at the relationship of OIC and Synergise as both the client under the TPA and the shareholder under the MOU. And your lordship will remember the express provisions providing for the coextensivity, or those relationships being coextensive, each dependent formally on the other, and these agreements clearly being signed, as I say, at the same ceremony. And if one needs to, and if one goes to the documents, I think your lordship's at 1669, if one just goes back a few pages to 1662.
Yes.
This is Mr. Schoffel's email of the 9th of October 2014.
Yes.
And one sees in this email, OIC does not intend to become majority shareholder, only then to relinquish all powers and to have no say in the management of the JV. Whereas we do contemplate this transaction because we think we may benefit from GlobeMed's more advanced claims in handling technology. We do, as potential majority shareholders, intend to develop a profitable operation supported by the business that OIC can be entrusted with and the additional business we can produce. So that is the expression of hope that both will be, OIC will be integrally involved in its role. Mr. Karma's reply is at 1664. And your lordship will see there, second paragraph, first and foremost, we're in agreement that this will be a joint venture between us, and we're committed to work together to identify mutual grounds that would secure all the provisions rendering this JV a success. So again, the interdependency of the shareholding under the Memorandum of Understanding and the service agreement, the client relationship under the TPA, is made very clear on the contemporaneous documents. We note too the fact that GMGS relies heavily on the MOU in terms of its damages claims. You'll recall there are the projections of the financial profits. So to the extent that that GMGS may be seeking to rely on the TPA but ignore the MOU, there's clearly in our submission an element of approbate and reprobate in GM's sort of core case, if I can call it that, on the severability of these two agreements. The fundamental issue in this case, we say, is the interdependence of those agreements, and that we say is fundamental to the application to the new claim, to the synergized claim, and to the claim the claim should be set off. GlobeMed rely substantially on the mutuality of obligations under the relevant provision in the civil code, to which my learned friend took you briefly.
Yes.
And your lordship, I think, analysed it, the sequence of events. So, to the extent that renunciation was not accepted, it was suggested that OIC could have tendered Synergize could have tendered the US $1 and would then have been entitled to the shares. Well, in our submission, which I've developed, the US dollar consideration for the 51% shareholding, which is obviously has a very significant value, is in effect the Dubai equivalent of an English peppercorn. There is no expectation where a peppercorn rent, for example, is required. The peppercorn will actually be transferred or tendered. It's merely there to serve a legal purpose in formalizing in peppercorn case, the lease arrangement, or here the contract for the transfer of the shares.
But I'm sorry, Mr. Reed. Mr. Reed, I'm sorry. It's commonly well understood that in these transactions, there's a meeting of mutual tendering. And at the very least, there has to have been offered, usually at one and the same meeting, an offering of the consideration for the shares and the execution of the instruments of transfer. Peppercorn rent or not, it's not, I've had no authority brought to my attention that under UAE law, the fact that the consideration is $1 means that has some particular significance because of its apparent small value.
Can I come on?
At the very least, there has to have been a offer to tender the $1, and it's at the moment, it seems to me, that there having been a renunciation of both the MOU and the TPA, and the interconnection between the agreements which you are relying on, the party seeking to enforce the sale of the shares provision would have to make it clear that its renunciation of the TPA is rescinded.
So the party making clear the renunciation would have to make clear that the renunciation was rescinded. I'm sorry.
The renunciation of the TPA was rescinded. Because otherwise it's quite unreal to think that the share transaction can be enforced, which was an integral part of the joint venture, as to which the TPA played a vital role. It's unreal to think that those shares should go over, and the renunciation of the TPA remain in place.
Can I address your lordship's first point on the fact that no meeting was held? There is no evidence before this court that GlobeMed made any efforts to convene such a meeting, or indeed to transfer the shares. And on the point as to the my peppercorn point, if I can call it that, could I just take your lordship quickly to the authorities on that point?
Yes.
Your lordship was referred to the difference, or there was some explanation. There was a difference in translation in the relevant provisions. I think the provisions as set out in my learned friend's skeleton come from Whelan, and if I could take your lordship to the to Whelan as added to the bundle so the authorities bundle at tab 6, page 926J.
Yes. Yes, I'm there.
And does your lordship have 926J, which should
yes,
be
I have. I'm looking at
Article
it.
247?
I'm looking at it now.
Great. So your lordship there sees in contracts binding on both parties, it's if the mutual obligations are due for performance, each of the parties may refrain from performance of his obligation if the other contracting party does not perform that which he's obliged to do. Now, this is a very common issue that arises in property disputes, so where a purchaser of a property has failed to pay for it, and then there's often an argument as to whether the relevant infrastructure had been put in by the time of payment. And what tends to follow is then an argument as to whether the relevant obligations under the agreement were specifically intended to be mutual, and so one therefore has an analysis of the contract, an analysis of the context of the contract in seeking to determine the sequencing of the obligations and what is to be paid when. There is, in fact, some commentary in the Ministry of Justice, to which your lordship hasn't been taken. So your lordship has been given Whelan's translation of Article 247, but has not been given the commentary, which is in the following page of this extract, page 926K.
926.
926K. So we've just been looking at Article 247 of the Civil Code.
Well, I went to what is indexed as the UAE Civil Code and Ministry of Justice commentary extracts, 929A to 929AO, and that's what I'm in at the moment.
Okay, the Civil Code provisions are in the order in numerical order. So if your lordship could go to Article 247.
Now this is, you can't give me a page number.
It could be 929K, my lord.
And I've got 2.0269 commentary on that.
Yes, that's great. So
it's
the page before that is Article 247, on which my learned friend relies.
Yes, I see. 247. If contract findings. Yeah.
So the critical issue there is whether the relevant obligations are mutual or not. And as I say, that is normally an issue of construing the contract as to the intentions, the agreement as to the sequencing of the relevant obligations. And if it's clear that they must be paid, or that the obligations must be performed at the same time, then they are found to be mutual obligations, which is when Article 247 applies. So the first point is that it's a matter of construction of the relevant agreement as to when the payment or the good or services must be provided. Sometimes it may be prepayment, sometimes it may be payment after the event. But the requirement, this provision, only takes effect where the relevant obligations are found by the court to be mutual obligations. And that, as I say, is primarily a matter of contractual construction. But regardless...
Are you going to... Sorry, Mr. Are you going to tell me that properly construed, there was no mutuality as to the $1 and the obligation to execute instruments of transfer for these shares?
Well, we say it's not spelled out. There's no express provision that the $1 must be paid.
It often is not spelled out. But come on, looking at this agreement in its commercial context, at the moment, I can't see how it can be seriously argued that these obligations were not mutual. And what happens when there is, hang on a moment, what happens when there is a renunciation is that the counterparty is entitled to maintain that the agreement remains on foot. And in those circumstances, it can pursue such rights as it has on that footing. Now, that means that if the renouncing party wishes, in fact, to go ahead with the agreement and to acquire the shares, it has to rescind its renunciation. It has to, there being mutual obligations as to the price and the execution of the transfers, it has to tender the $1. And at the moment, as I see it, it has to rescind its renunciation of the TPA.
Well, my lord, that's in circumstances where the non-renouncing party has not accepted the repudiation. So in those circumstances,
I'm sorry. Of course, the non-renouncing party has said, "I'm keeping this agreement open," which means that the non-renunciating party is at risk that the renouncing party will rescind the renunciation, and on that basis, we're all back at the races, and off we go. But that will only apply, as I see it at the moment, if the renouncing party rescinds its renunciation, it tenders the $1, and it rescinds its renunciation so as to give proper and sensible notice to the counterparty that the renunciation of the TPA agreement is rescinded.
Your lordship's taken a view. I mean that
well,
appears
at the moment, it's not a final view. It's not set in concrete. It's usually helpful for counsel to know the way a judicial mind is working. But the judicial mind is open to any submissions designed to persuade me to the contrary. But at the moment, that's the way I'm looking at things. But if you've got any specific points that blow that analysis below the water, and it's not to be a final analysis, please draw them to my attention.
Well, my lord, I do wish to say that. I mean, start by saying that no evidence for that analysis has been put forward as a matter of UAE law. As a matter of principle, broad commercial principle, we would say that where there has been a repudiation, if it's not accepted, then it's not clear to us as a matter of UAE law. We've seen no evidence that there's a requirement then on the rescinding party as a repudiating party to rescind its repudiation in circumstances where the other party has never accepted the repudiation. We do say, as a matter, insofar as we are able to assess UAE law, that even where the mutuality provision in 247 applies, there is a de minimis principle that in effect applies, and one sees that from the Ministry of Justice commentary that has not been included in the with the materials that have been the UAE law materials that have been put before the court, and which we have put before the court. And I think your lordship had those. Your lordship referred to paragraph 20269.
Yes, I did. Yes, I'm looking at it.
So if I could just read, this is the Ministry of Justice commentary on the code. One of the principles on the system of contracts binding on both parties is based is the connection between the mutual obligation to be formed on the basis of mutual exchange. If performance of these obligations is due, then one of the two contracting parties may not be compelled to do that, which he's obliged to do before the other contracting party performs his corresponding obligation. On this basis, the corresponding obligations must be performed at the same time and may be derived from the procedures of actual tender in order to ascertain which of the two contracting parties is making failure in performance. So pausing there is no defined procedure of tender under this agreement, the MOU. Thus, each of the two contracting parties has the right to withhold performance of that which he's obliged to do until he's given that which he's entitled to. And by relying on that right of defence, he is doing no more than to suspend the operation of the contract. The contract is not cancelled in such a case, nor are the obligations arising out of it terminated in any way. It's simply a question of the halting of performance, which is fundamentally different from cancellation and the defence of non-performance of the contract. So essentially, there is a suspension, and then critically for our purposes, however that may be, it's not permitted to the contracting party to abuse this defence. It's not open to him to rely on it in order to withhold performance of his obligation if the corresponding obligation has been performed as to a large part thereof, and the part that remains unperformed is minor to the extent it doesn't justify taking such a step. So we would say that the obligation to provide a dollar, which we say is equivalent to the English peppercorn, is precisely a minor obligation, which insofar as it is unperformed, doesn't justify the failure of GlobeMed to transfer and Karma Holdings to transfer the shares under the contract, which it is maintaining is still live and which appears under the commentary to be merely suspended.
Well, I don't read that way. I believe that what that is dealing with is with the situation where one party says there is an absolute obligation that must be fully performed before there's any obligation on him. And there are those cases, that wonderful case where Lord Atkin gave judgment in the House of Lords, that you've got to construe the contract. If you are purchasing metal rods, which have to be the absolute length specified in the contract with no margin of variation, then a failure to tender rods of that sort is a failure, and there can't be an abatement of the price. But often the court will look at what is said to be an absolute obligation and will conclude that something less than the fully stipulated obligation will be sufficient to give rise to an obligation on the other side subject to an abatement of the price. And that's how I read the provision you've just taken me to. There's nothing here about if a peppercorn rent is being offered, you can ignore that as an obligation at all.
Well, it is saying that to the extent that a minor obligation is unperformed, that doesn't justify the withholding of performance of the obligation. And insofar as one is seeking to...
I'm sorry, it says if the corresponding obligation has been performed as to a large part. The corresponding obligation is for the payment of $1, and it's not been performed at all. This isn't caught by this provision, in my view.
In our submission, the mutuality obligation in 247 is subject to a broad de minimis principle, which this second paragraph in the commentary illustrates. One can take a very technical English view as to what should happen and the sequencing of the tendering. we say that as a matter of UAE law, the tendering requirement to tender $1 is substantially a formal requirement, which cannot be insisted on as the basis for a failure to transfer a very substantial body of shares of very substantial value. We note too that the court isn't required in construing this principle, this provision in the Civil Code. Looks not only at the commentary, but is also in the commentary invited to consider a number of sources, and you'll see at the bottom of this page the suggestion of comparison with the Majalla, which is the Ottoman codification of the underlying Islamic law, and indeed a commentary, Ali Haidar, on that underlying Islamic law, and is also invited in considering the principles set out in the provision and indeed in the commentary to look at the corresponding articles from the civil codes of other countries, let's say Jordan, Egypt, and Syria. And we've seen in the Nest investment case, the courts doing just that, being provided with evidence on the where a party is seeking to strike out or seeking immediate judgment, where that party has the burden. It's for that party to establish clearly the relevant principles in respect of that provision by reference to the exegesis or the surrounding authorities. And we say that is what has not been done by GMGHS in its strikeout application, and indeed by GM in its strikeout application in seeking to strike out the synergized claim. Article 556 is the other provision which is lightly relied on. Your Lordship has that in the same clip.
Yeah.
Does Your Lordship have that?
Yes.
So the purchaser must pay the price when the contract is initially made before the delivery of the thing sold, or a demand is made for it unless a contrary agreement has been made.
Yes.
And then one sees on the following page the commentary. The obligation to pay the price is conditional upon the goods being ready and available, and the price being contractually due immediately rather than deferred, and there not being any relevant option available in favour of the purchaser.
Yeah.
And so, again, one has to determine whether there is contractual provision for the price to be paid immediately. Well, we say there is no such provision. And similarly, there's no provision for it to be deferred. So in our submission, the Article 556 adds very little to the existing debate as to whether there is mutuality of the relevant obligations and whether that mutuality applies in circumstances where the consideration is a de minimis or a minimal amount of $1.
Yeah.
And again, on this section of the commentary, one sees the reference to the Majalla and to a number of underlying both Islamic authorities and also the civil codes of the various other jurisdictions. So we say that GlobeMed was therefore required to transfer the shares. And indeed, as your Lordship suggested, as part of its claim, part of the GMGHS's claim, on the counterfactual, it is required to consider what the position would have been had this obligation, the obligation to transfer shares on the part of GlobeMed, be considered.
Yeah.
And it's said that the entitlement, I think finally, the entitlement is no longer available. And it's accepted that this creates an inchoate unfairness, which is then said is self-inflicted. And it's said that it's too late now for Synergize to pay the US dollar. But of course, Synergize is not seeking specific performance. It's seeking damages for GlobeMed and Karma Holdings' failure to perform its obligation under the MOU
Yes.
Now, if we're right that the synergized claim is prima facie or is arguable, then there are a number of options in terms of taking that forward. Firstly, it could be that GMGHS then rushes to judgment in the main claim by insisting on a separate trial. In our submission, that would be profoundly unattractive, and one could see precisely why it would want to do that in terms of seeking to put GMGHS in a position where it can enforce, and then assets and funds can be withdrawn from GMGHS into GlobeMed in BBI or in Lebanon, and obviously to the extent that the synergized claim is then sought to be enforced against Karma Holdings and GlobeMed in Lebanon, clearly there would be difficulties in enforcing that synergized claim. So either the main claim goes ahead in advance, essentially GMGHS, we would say, stealing a march, or they are managed together in such a way that there is a single trial and the judgments occur at the same time. We say that would be suboptimal as well, because the same structural unfairness would exist and the same potential for GlobeMed to essentially seek to take the benefit of recovery in the main claim, but deny recovery and enforcement of any benefit of the synergized claim. We say that would be profoundly unfair. And the way we say that would be remedied, or could be remedied, should be remedied, is to give an option to the trial judge to allow the claims to be set off. And we say that what GMGS is doing in seeking to remove that option of allowing a set off is precisely to give it that position, where it's a strategic position that it can essentially enforce its claim on the basis of the windfall, the full 100% of the projected profits, and then fight a rearguard insofar as any enforcement is sought of any judgment on the synergized claim. We have maintained the English equitable test. As Mr. Knight suggests, we think it likely that it's UAE law that applies, because we think as a matter of UAE characterization, set off is a matter of substantive law and therefore falls to be decided under Lex Causa. But it's that position, that characterization as a matter of UAE law and UAE conflicts of law is not clear, and therefore we have reserved our position. The English test.
Is this a case where renvoi will apply? If there's a reference to the conflicts of law rules of the UAE,
well, the renvoi would require UAE conflicts law to refer to GIFC or to the.
Yes, well, they may.
It may do. There's some analysis that's required on that. I have to say we haven't considered the renvoi point. That's helpful. But at the moment, the set-off is put, as your lordship saw when Mr. Knight took you to the relevant section of the pleadings, on the basis of close connection, sufficiently close connection that it would be manifestly unjust for the claim to be enforced without the other claim being set off against it. And we do maintain that position, that is the fundamental test. And in circumstances where the debt in one case, or the relevant parties are in one case a wholly owned and entirely controlled subsidiary, and in the other case a majority owned company, we say the coincidence of interest of those companies is so strong and the connection is so strong that there is a case, and it's arguable that an equitable set-off would apply as a matter of GIFC law. I should add that there is no, I don't think either party has found a DIFC case on set-off, and to the extent that the DIFC courts would apply English law, one has to bear in mind that the DIFC courts flesh out the statutory provisions of DIFC law by reference to general common law principles, and it's not entirely clear that how English law or indeed general common law principles would be applied by the DIFC court. So there's an element of uncertainty there, but we expect that if DIFC law were to apply, then the broad common law test in terms of sufficient connection, that it would be manifestly unjust. We suspect that that would be the test. And one doesn't, in the English common law cases, see an express requirement of what Mr. Knight referred to as pure mutuality. There may well be circumstances where the claim, the second claim, if you like, involves a wholly owned subsidiary. For example, the obligee is a wholly owned subsidiary of the obligor. In the other case, there is no authority that we could find suggesting that precludes, as a matter of English law or common law principle, they're being set off, as long as a broad equitable test is satisfied. Insofar as UAE law applies, we make the point, obviously, that that insofar as the English approach applied to UAE law, that this would be a matter for trial, it would be a matter for determination on the evidence of experts and on the cross-examination of the experts. And we say, given that the value of the set-off may be in excess of $18 million on GlobeMed's case, it would be proportionate to have experts rather than submissions from Mr. Knight. I've made one of the points about strategy and Synergize being potentially left to enforce a claim against GlobeMed in BVI and Lebanon. I should add to that the fact that there's no particular advantage in terms of case management or striking out the set-off claim. That the strikeout would not let out GMGHS. GMGHS, after all, is a claimant already in the main claim and will need to attend the trial. And the set-off issue is to some extent already raised in paragraph 9b of the re-amended defence and counterclaim, albeit it's worded in terms of a discount of 51% to the damages to which GMGHS would be entitled if it succeeded in its claim in the main action. In terms of the UAE law of set-off, we say the detailed provision in respect of the specific instances of set-off is in Articles 369 and following. Your Lordship should have those in the same clip of authorities.
Yeah, just give me a moment. Now, is it the civil code or the federal law?
It's the civil code, so it's the clip that we were just looking at a moment ago.
No, I'm there. Yes,
and so
I'm there.
So if your Lordship goes back to Article 369.
Yes.
So this identifies the very specific species of set-off, so mandatory, voluntary, or judicial occurring by order of the court. Mandatory set-off is then dealt with in the following provision on the following page, Article 370. And there are 4 specific conditions that are set out in Article 370. So the first is that each of the parties must be in debt to the other, and that, I think, is what my learned friend has referred to as the mutuality of the debts.
Yes.
And then there are 3 other specific conditions, and we say that these are the 4 specific conditions of a mandatory set-off. And if these conditions applied in respect of a discretionary, a judicial set-off, then there would be no reason to require, first of all, the exercise of discretion, or B, the application to the court, which is the express condition of a judicial set-off. Judicial set-off is provided for at 372, which is a couple of pages on in the same clip.
Yes, I'm looking at it, yeah.
A judicial set-off takes place by order of a judge if the conditions thereof are satisfied upon an original or an interlocutory application. So I would emphasize there the word thereof. So it's the conditions of a judicial set-off need to be satisfied. And we say impliedly those are not the conditions of a mandatory set-off. And that obviously then begs the question as to what are the specific conditions of a judicial set-off. And your lordship has seen the judgment in IGPL. I don't think I need to take you to that, but
no.
As your lordship can no doubt remember it. But the focus of that judgment is on whether, in the case of a judicial set-off, it's necessary to make an application. And the court recognised, and the reasoning, the ratio of the court was precisely that such an application is required as a condition of a judicial set-off. And there was, your lordship will have seen the reference to where the Chief Justice sets out what he thinks are conditions of a judicial set-off. And I would accept that he includes in his list mutuality, but he does it very guardedly. First of all, he makes clear that what he's saying is obiter. And secondly, he makes clear that what he's saying is on the basis that it's probably correct. His words, having heard a very substantial amount of expert evidence on another issue, on the issue of whether an application is required. Now, in our submission, to go from the Chief Justice's obiter comment that mutuality is probably required is not a proper ground for seeking to strike out a claim based where there is where the strikeout is based on an assertion that mutuality is a strict requirement. In our submission, it is still arguable, notwithstanding the obiter views of the Chief Justice in the IGPL case, that there is not, in the case of a judicial set-off, a strict requirement of mutuality, and that it's open to the court where there is, in the English terms, such a strong connection, as is the case here, to allow a set-off in the exercise of its discretion. And indeed, the view of Mr. Mutasib, as set out in his witness statement, which your lordship will have seen, is that there is no requirement of mutuality. And indeed, he refers to the concept of correspondence, which appears to be the notion adopted or referred to by Professor Sanhuri, which is, in our submission, something less than strict mutuality. There has to be a broad correspondence between the debts, between the claims, which again is remarkably similar substantively to the English notion that they be so closely connected that it would be manifestly unjust. And in our submission, correspondence captures that same sense of a requirement of connection, but without a strict requirement of mutuality as advocated by the learned friend. Circling back to the Article 368 point made by Mr. Knight this morning,
Yes.
We say where one has very detailed provisions in the provisions we've just looked at, so that's 369, 370 and 372. So where, for example, 370 lays out 4 very specific conditions for a mandatory set-off, and where we say 372 then provides specifically for the condition of a judicial set-off, namely that an application needs to be made. That 368 provides a broad statement, a general explanation, as you like, if you like, as to what a set-off is in broad terms, but without the detail which you then have to find in the subsequent provisions. It is the introductory article in this section in the Civil Code. And we note again that if one looks at 368, the commentary refers to the commentary to Article 377, So if you're seeking to interpret 368, the commentary refers you to the commentary to 377. That in turn, maybe worth looking at that now. So we have 377 on, one turns on a number of pages in this clip.
Yes.
And then the page after that, paragraph 20551 from Whelan, which is the Ministry of Justice commentary. And again, there is a reference to the comparative Sharia note and various Islamic scholars, Murshid, Al-Harayan, Rad al-Mukhtar, and again, the codes of Jordan, the civil codes of Jordan, Egypt, Syria, and Iraq. So if one is going to attempt a conclusive analysis of these provisions, and indeed of 368, one really needs to look at those sources, those authorities, as indeed the Chief Justice did in IGPL on the specific issue as to whether an application is required for the purpose of a judicial set-off. And my learned friend also took you to a number of Court of Cassation cases. I think it's possibly easiest to look at those in my learned friend's skeleton.
Yeah.
And he has them at para 109.
Yes, I'm looking at it.
There's a danger sometimes with Court of Cassation cases that one can often find as many on one side of an issue as on the other. Putting that general caveat aside, the first of these cases, Cassation 345 of 93, is clearly focused in our submission on the issue of capacity. So judicial set-off, the two debts shall be opposite. That's the two debts to a set-off shall be creditor and debtor towards each other in the same capacity. So the emphasis there, we say, is on that, and that's clear too from the following paragraph in Mr. Knight's quotation from that cassation decision. And then if one looks at the following decisions, they are all substantially setting out what is said in 368. So Cassation 28 of 1998, it is established by this court that set-off regulated by Articles 368, 370, 372, satisfaction of a debt owed to a creditor by a debt owed to his debtor. So that's the same general introductory text that one sees in 368. The following cases, all of them, so Cassation 306 of 2000, Cassation 67 of 2004, Cassation 2209 of 2011, all of them refer expressly to Article 368. The first of them simply quotes Article 368, and therefore in our submission adds little to the statutory text, and the remaining two do little more than essentially set out what is in 368. So we say that 368...
Sorry, can I just ask you this? Do forgive me. Were these judicial set-off cases?
Well, the first one is...
Well, yes, they are.
I will need to look at the subsequent ones, but all they are doing, we would submit, is essentially setting out what is said in 368, which is in broad terms an introductory article in the relevant section on set-off, where the detail is found in the following provisions, specifically 370 dealing with mandatory set-off and 372 dealing with judicial set-off.
Yes.
And so, my lord, we say that the correspondence is clear, that when one looks at the claim being made by GMGH in the main action to the total profits, and what is essentially being said in the synergized claim is that Synergize there should be a discount to reflect Synergize's share in those profits. There's clearly a correspondence. And I'd repeat the point we made earlier about Synergize being both a shareholder under the MOU and a party to the TPA. The correspondence between the debts is reflected in the correspondence between the relevant and underlying agreements. And we say it would be manifestly unjust for GlobeMed and Karma Holdings to profit from their failure to transfer the shares, where they essentially seek the windfall. They strategically seek a windfall by seeking to leave Synergize to enforce in Lebanon, which has all of its issues around corruption and judicial corruption, whilst they seek to enforce the main claim in Dubai. And we say the set-off claim does have a real prospect of success and should not be struck out. It should be allowed to proceed to trial. I don't
Could you
think
help me with this, Mr. Reed? So sorry. If I don't raise it, it'll go straight out of my head, so do forgive me. If the contention in the main claim that the claimant must accept a discounted recovery because of the obligation to transfer 51% of the shares succeeds, what's left of the what's left of, if you like, of the new claim? The judgment that would be obtained by the claimant in the new claim would be for 49% of otherwise of what is 100% recovery would be.
I don't want to put an argument into Mr. Knight's mouth, but I think when he as he sought to explain earlier, the claimant in the main claim is GMGHS. So
yes,
I
understand that.
So he will say, well, the shareholding of GMGS is a matter of irrelevance, and GMGS is, he will say, entitled to claim its in all of its contractual entitlement and the profit it says it would have made under the TPA.
Yes, but
as to whether
sorry,
it benefits.
No, what I'm putting to you specifically, there is a plea that there has to be a discount in the proposed defence. There is a plea, there has to be a discount to recognise that, in fact, if the whole thing had gone ahead, which is the basis of the counterfactual assessment, the shareholding that the claimant would have had would have been 49% and not 51%. Now, let's just let it be assumed that that was held to be the case at trial. What is left with Synergize's proposed claim and as to the proposed settlement?
Well, if the court found that there should be a 19B discount as pleaded in the defence, the re-amended defence and counterclaim, then there would be no need for the Synergized claim or the set-off. The difficulty is the technical points that Mr. Knight will make and has intimated in circumstances where the claimant and the party to the TPA is GMGHS, and where what we said, what GMGHS would then have done with its profits in distributing those profits as amongst its shareholders is a matter of irrelevance to the court in deciding GMGHS's claim under the TPA.
Well, I'll hear a little bit more from Mr. Knight on that, but thank you for your response. Thank you.
I don't think we've raised in our skeleton the entitlement to a declaration, and I don't think any point has been taken either in Mr. Knight's skeleton or indeed in his oral submissions on that. So unless I need to address your lordship on that, I won't. Similarly, the intimation, the allegation of an abuse of process, I don't think has been maintained, and so I won't address your lordship on that unless Mr. Knight indicates or your lordship indicates that I need to do so. I do, however, need quickly to deal with the co-management issue, which would apply.
If submissions in the course of the submissions you've made this morning, but of course, yes, do go on.
Well, my lord, your lordship will be aware under RDC 4.28, the courts have power to hear claims together. Your lordship has in the authorities bundle the Ixis case, in which Mr. Justice Akins, essentially found that that discretionary power was exercised by reference to the overriding objective. Your lordship's heard. I'm not going to repeat my submission in terms of the it being obviously sensible that the main claim and the synergized claim should be heard together, dealing as they do with the same transaction, related agreements. The issues of UAE law, which would make it plainly advantageous that there be one trial in which the relevant UAE law experts attend, we say the issue of the severability or interdependence of the agreements is live in both sets of proceedings. So we say that if the set-off, assuming the synergized claim is pleaded, there's no sense in the main claim proceeding first. The only benefit is a tactical, strategic benefit to GlobeMed in allowing it essentially to steal a march and get its judgment first and seek to enforce that judgment first. As I say, I've made the point. Essentially, we say that the additional claim is, and I think Mr. Knight's accept this, effectively a counterclaim. GlobeMed is essentially GMGS being the 91% shareholder. OIC is similarly essentially Synergize being a company that it wholly owns and controls. And if the claims were not heard and tried together, there would be a real risk of a substantial duplication of time and costs, and indeed you'd have a second trial on the basis of dealing with the same transaction, whether severable or not, dealing with the same issues. As your lordship's drawn attention to the fact that there's the 19B discount, which to some extent there's some overlap between that and the synergized claim and the set-off claim. The same witnesses in terms of the agreements and indeed potentially the same experts on UAE law. So it would make no sense for these claims to be managed separately. They should be, in our submission, managed together.
Yes. I think that therefore concludes your submissions. Is that right, Mr. Reid?
My lord, that concludes my submissions.
Well, I'm most grateful for your submission. Thank you very much. In reply, Mr. Knight. Is Mr. Knight there?
Sorry, I'd muted my microphone. I've just been merrily asking you a question, my lord. My lord, I'm going to be very brief, but you did mention that you'd like me to address the issue of the discount come set-off point and their interrelationship. And I wondered if you could just reformulate it.
Sort of whole picture, yeah.
Sorry, my lord. I just wondered what the point you were concerned by.
What is your answer to the plea that the claimant would have to accept a discount on its damages because the MOU and the TPA are closely connected? They are all vital and connected components of a joint venture agreement. And so the counterfactual is going to be to have regard to both those agreements. And accordingly, in those circumstances, the position if both are if both are being performed, the claimant will have on the counterfactual would have transferred 51% of its shares.
Well, my lord, our answer is one of corporate or legal personality, and that's essentially going on to reflective loss, because it's a matter of control and dividends, and it may be that the shareholders in GMGHS would have been entitled to take the profits, or they were entitled to it, they always are. But that does not mean that GMGHS itself is not entitled to all the money, because it still has to pay it out to its shareholders in the proportions of those shares. Now, it may, as far as GlobeMed's concerned, have gone elsewhere, but that is not GMGHS's business. And
Yes,
the answer to it was they just had to go ahead with the MOU, and they have repudiated it, or attempted to repudiate it, and they have made an enormous mistake.
Yes. Yes. Right. Thank you.
My lord,
brief reply on
a couple of points
on
which may be points of confusion. We did refuse to accept the renunciation. We pleaded it at paragraph 19 of the particulars of claim, and
yes.
The defence does not deny that we have refused to accept the repudiation.
Yes.
The other perpetually frustrating confusion that appears is that we're in some way relying on some contractual liquidated damages relating to the accounts set out in Annex 2 to the Memorandum of Understanding. We have expressly pleaded at paragraph 26 of the particulars of claim that this is indicative only, and that it has been done in order to show the sort of damages that we're entitled to and the sort of way it would be calculated. We have gone into this enormous length in the course of disclosure, and I think your lordship has agreed with us that because we are not relying on that as some sort of liquidated damages, we need an expert, we need full disclosure of OIC's accounts in order to calculate that to which we are actually entitled, because we do not say that these two are connected by this liquidated damages clause, this account. We are purely using it as illustrative, and I hope that assists my learned friend in due course, should he need it, because it has been persistently referred to in correspondence, and we have persistently replied to explain the position, but it doesn't seem to resolve the issue, but hopefully that will. My lord, another point, a small point that I picked up, and I think your lordship picked it up too, was one of mutuality, but not with respect to the set-off, but with respect to the mutual obligations in the MOU, and my learned friend suggesting that the payment was not mutual with the delivery of shares. One only has to read clause 3 of the MOU, that the investment entity will acquire 51% of the shares against a total sale price of $1. Accordingly, GlobeMed will relinquish its shares, and Karma will relinquish its shares. It is misconceived at best to suggest that this was not a mutual transaction. The only other point I have is that any argument that relies on Article 368 not being applicable, or is in some way just being a sort of general preamble that you don't need to take any judicial notice of in the definition of set-off, if that is the extent of my learned friend's argument, that he is right to ignore it and that Mr. Mutaseb is right to ignore it, when every authority that we can find expressly refers to it, and there is no other mention of corresponding debts in the legislation. The corresponding debts does appear to come out of 368. That's where this correspondent debt notion derives from where it derives. And any argument that 368 is in some way can be ignored simply means that the case is doomed to fail. I don't know whether your lordship would like me to address you on the management issues.
Well, just briefly, please.
I mean,
the whole thing is predicated upon the new claims proceeding.
The problem with the new claim is that they can't serve it. So the benefit in not the biggest benefit in not amalgamating the claims, apart from the waste of costs in them, is the absence of delay. It was that the application was simply premature. I mean, what you're asked to do is consolidate the claims without Karma having even been asked.
Yes.
We've got to wait for an unknown period, which is in the hands of OIC as to when they get round to serving. It's partly in third parties' hands, but it's certainly partly in OIC's hands, and they can simply delay doing it. And the period expires, and they can go back to court and get permission to extend the validity of the claim form. But to now, for what are entirely separate claims and do not involve the same issues, they have separate parties. And to just keep repeating that parties are effectively the same because they are subsidiaries of one another, it is just entirely misconceived as a matter of law. There are different claims by different parties against different parties, different agreements, and they have different implications and very little factual overlap in them. They're essentially matters of construction. So we say it is entirely wrong to wait for Karma to be served for an unspecified amount of time. The main claim can go ahead and be determined. If the new claim in due course proves successful, then so be it. That they will be able to set off if they're entitled to. They can apply for a stay after the claim has been finished.
Yeah.
But it seems to us that you simply it is just occasioning delay. There is no real advantage to it at all.
Yes.
That's our essential submission on it. That there are other matters to which I've referred in my skeleton. I see no reason why the two matters should be conjoined, and until Karma has been served, it seems to us that it's a premature application in any event.
Yeah.
My Lord, I want to come back on just 2 points. Firstly, the suggestion that somehow that OIC is delaying service on Karma Holding is completely nonsense. And the use of the language when we get round to serving is completely disingenuous. As is well known, where there is service in another Arab League country under the Riyadh Convention, service has to be performed through the court. So we are dependent on the Lebanese court in getting around to serving on Karma Holdings in Lebanon. Now, in theory, that should be an acceleration of the process because one doesn't have to go through courts, Ministry of Justice across to the corresponding Ministry of Justice and down to the courts in the country of service. The reality, however, is that it can take somewhere between, we understand, 2 to 6 months. But this is in a context where security for costs, which was promised in January, has still not been provided, notwithstanding that it was to have been provided in March. So there have been very significant delays on the part of GMGHS in providing and GlobeMed standing behind it in providing security for costs. So there is already a significant element of delay, not least after the months of resistance to security, which caused a significant delay, but now the months of delay in providing that security. So in the great scheme of things, the the insistence of Karma Holdings that it be formally served under Lebanese law and under the Rio Convention, that is not causing any significant delay in terms of holding up the proceedings, the global proceedings, which in our submission should be heard together. One has to bear in mind that it said that we should have written to Karma Holdings, but Karma Holdings is entirely controlled by Mr. Karma, who is the CEO and chair of GlobeMed itself. It is Mr. Karma himself who is authorizing Clyde & Co. To act in these proceedings, and he said that he's not. He's requiring service. To suggest that we should be writing to Karma Holdings and that we shouldn't have written to Clyde & Co. asking whether they were instructed in our submission is a thoroughly bad point. I would wish to finally conclude by saying that if the grounds for striking out the synergized claims are that as a matter of UAE law, it would be required where there has been a repudiation that is not accepted, that the repudiating party then rescind its repudiation and then tender $1. We say that submission should have been made good as a matter of UAE law, which is the governing law of this dispute, and it hasn't been. And for it to be alleged or suggested submitted that Synergize has no real prospects on the basis of that alleged sequencing or the requirements that those events happen in that strict order without any basis in authority as a matter of UAE law would, in my submission, is a thoroughly bad submission, and Synergize ought to be permitted to make its claim in order to prevent the very real injustice that may occur if it's not permitted to bring the Synergize claim.
I should just perhaps add on that last point, it was not my submission, it was your lordship's.
No, it was mine. Yes, it was. It wasn't part of your submission. Well, I think
that submission.
I think that concludes matters. I'd be no surprise to you that I shall reserve my decision. Your solicitors have been asked within a few days to provide quite a lot of the material in Word for obvious reasons, and I'd be grateful if that can be done. I think I said I'd like this within 7 days of the conclusion of the hearing, and that will be of great assistance to me. Thank you both very much for your submissions. They have been illuminating and helpful. I have a great deal to think about, and so it'll take a bit of time to produce a reserved judgment, but I will attend to it with such dispatch as I'm able to, given other commitments to the Dubai court. And thank you to the registry and to the court for organising this hearing. If there have been any delays at all, they've been because of my technological incompetence and not for any other reason. And the hearing has gone really extremely well. And so we now adjourn. Thank you.
I'm obliged to you, Lordship. Thank you very much.
Thank you.